All right. It's the appointed time. We have a quorum. I call to order the meeting of the Bills Committee. I will first invite representatives of the administration to come inside the conference room. Members, after the last meeting, the Secretariat has posted a notice on the LegCo website inviting public written submissions on the bill. The deadline for making submissions is 5 p.m. on 25th of February, next Tuesday. All right. The administration has given a written response on issues raised at the last meeting. The paper number is CB brackets 1216/2025 brackets 02. The paper has been uploaded onto the LegCo website before the meeting. It has also been sent to members. Will the administration please brief members on the response? Thank you. On 13th of February, we have submitted a written response on follow-up actions arising from the discussion at the meeting on 10th of February 2025. The first part of the follow-up actions is that we should consider whether it is necessary to provide in the clause to make sure the registrar may refuse the application of a company that may endanger national security. We believe our provisions are effective in addressing potential national security risks. One is that the registrar is given the power in the sense that if the intended redomiciled company is likely to be used for an unlawful purpose or for a purpose contrary to public interest, the registrar may refuse the relevant application. We believe this is already quite sufficient. Also, the bill will add a new section to the Companies Winding Up and Miscellaneous Provisions Ordinance. It should be able, Ms. Doreen Kong, yes. You have questions on this? All right, please proceed. Excuse me. I was saying there's going to be a new section to be added to the Companies Winding Up and Miscellaneous Provisions Ordinance. It will provide that if the registrar suspects that the redomiciliation application is made with the object of circumventing some society's ordinance provisions, it may be rejected. Also, the Secretary for Security may order a company to stop operating with reference to Chapter 61. We also know that in different places, there are different ways to address the potential national security risks, and we consider our approach to be appropriate at the moment with addressing the relevant concerns. Chair, I can wait until the Deputy Secretary has done briefing members on the response before I ask questions. I think you can perhaps ask questions on this part right now. All right? I looked at practices in other places, and I looked at Singapore Act 360 in a particular part. It is about company redomiciliation. Let's look at the wording they have. They are saying if a company is likely to be used for an unlawful purpose or for purposes prejudicial to public peace, welfare, or good order in Singapore, or it would be contrary to national security or interest for the intent of the company to be registered. Let me say this. It's not just me suggesting that Hong Kong should have that. The UK proposed similar provisions, and Singapore actually has that in law. The administration's explanation is that they have other laws. I do understand there are other Hong Kong laws that the company has to comply with, but I think we should focus on during the registration stage that we are already addressing national security risks, that we should be a gatekeeper in that regard. I do understand what the administration said. I am understanding, but then they should give us a proper written reply on this. I think the administration may review this and they can submit a written reply on the practices of Singapore, and they can perhaps further explain their legislative intent. Thank you. Please proceed. Thank you, Chair. Let me say this for the second part of the follow-up actions. It is about companies deregistering after they have essentially been redomiciled to Hong Kong. It will help companies maintain their legal identities, and in the bill's provisions, they have already provided for the effect of redomiciliation. The process of redomiciliation will not affect companies' continuity, will not create new entities, nor will it affect the different aspects of the company, including assets. And during the transitional period, we believe the process would already provide the basis of handling of such matters. For the redomiciled company, before they have canceled their registration elsewhere, with the additional compliance burden and operation, we believe there is actually incentive for the company to expedite their deregistration in the place of incorporation. We believe the 120 period has struck a proper balance between administrative facilitation and legal certainty for the companies. Excuse me, Mr. Ring Kong. Thank you, Chair. I would like to raise two issues. I still am against 120-day period. We have in many places a 60-day period. I don't understand why the period has to double in Hong Kong. We have seen 60-day periods being set in other places, and it has been quite effective. Why do we need longer? Are we slower, or do we expect the companies to take longer in Hong Kong to process the relevant deregistration? Also, I want to say this. We talked about with the transitional period, the company will be subject to regulation in 2 jurisdictions, and many members have expressed concerns. Well, with other jurisdictions, with a 60-day period, there would still be a problem. But then let me say this, in Cayman Islands or BVI, in their jurisdictions, they talked about with redomiciliation, outward redomiciliation, they specifically said their proceedings would go on while they have yet to deregister. So I think my concerns are somewhat allayed with this. Alright, administration. Do you have any figures you can share with us that during the transitional period, do you expect any changes or stakeholders' views, or are there any justifications with changing the 60-day period to 120-day period? I actually mentioned this last time during the consultation period. In fact, we have set out a 60-day period in our consultation paper, but many stakeholders have expressed that in some jurisdictions, a 60-day period wouldn't be sufficient. That's why they have asked for a longer period, and we therefore propose a 120-day period. As Ms. Doreen Kong said, we saw in some jurisdictions with outward redomiciliation regimes, they have in their legislation that they would maintain continuity of legal entities in their jurisdictions while the company is undergoing a redomiciliation process. And we believe that with the continuity of legal entities, there should be adequate protection. Ms. Kamen Khan. Thank you, Chair. I would say this. We have to make sure we understand that the major jurisdictions with outward redomiciliation regimes, their practices, and in general, it would be Cayman Islands and Bermuda. Can the administration provide information on provisions for ongoing proceedings? Like Ms. Doreen Kong said, in Cayman Islands, they did say if there are ongoing proceedings, the proceedings are to continue. I also want to know what happens when the company has deregistered from the jurisdiction. And I honestly have some doubts if the company has deregistered, can the proceedings still continue? And will the proceedings take place in that particular jurisdiction rather than having to move the proceedings to Hong Kong? Can the administration provide a response on this? I think the administration has also put in place a mechanism that would allow the registrar to extend the period. I think this is a provision that should already be adequate. I think the trade wants to make sure the period can be extended beyond 60 days. So why not just set a 60-day period? Since we are already allowing for an extension, why is it that Hong Kong needs to be so special that we need to set a much longer period? Is it the case that the banks or the insurance companies have particular requests or demands? We are mainly targeted banks and insurance companies, right? When they have deregistered in the particular jurisdiction that they were incorporated in, or that was their last domicile. What are there higher thresholds for banks and insurance companies in Hong Kong that would justify the 120-day period? I haven't really heard the administration provide adequate justifications on this. I think the administration understands your points, and let's see if the administration has any justifications with reference to the practices and laws in other jurisdictions. Thank you. Thank you, Chair. The 120-day period is a balance struck between different feedback. It has provided legal certainty and it is quite attractive to companies. As for other jurisdictions' legislation relating to outward redomiciliation, let us collect some info and then we will provide a written response. Mr. Chan Kim-po, of course, we are lawyers, so they have been looking at things from a more legal perspective, and I think I should speak on behalf of the financial sector. Let me say this. I think a lesser threshold will be better because the trade has expressed their feedback. I think they have their reasons. And I think you should listen to such feedback since you are consulting them. I understand that the other members have their other concerns. I think the administration can perhaps explain better their justifications with reference to stakeholder feedback. And I think when stakeholders give some feedback, we should listen to them. Thank you. Administration, any response? Well, I don't have any response on this part, but we haven't talked about the third part. with reference to adjusting upwards the proposed fees payable for the redomiciliation application, we have the fee levels determined on a cost recovery basis and with reference to existing fees and the estimated extra costs. And we will review the costs if necessary. And if necessary, we'll adjust the fee level. So that's the 3 parts of the response of the administration. Thank you. All right, members, any questions on the administration's response? Mr. Rincon?
Chairman, this has nothing to do with the government's response on the overall drafting of the bill. I have some questions for the administration. When can I put the questions to the administration? On the policy matters, no. On the drafting of the bill. You may raise the questions now. I've been reading this thick set of marked up copy. And I was wondering why we have to make so many amendments to the company's ordinance. Is it the same for other jurisdictions that intend to implement such a regime? So I look at the laws of other jurisdictions. I think for other jurisdictions, only amendments were made to a few sections of their laws. In gist, the amendments are about making the redomiciled companies the same as the locally incorporated companies. There are fewer than 10 sections in the Companies Act of Singapore. I want to ask the DOJ, when you thought about how to draft the bill, why did you come up with this thick set of marked up copy? What were your considerations? Deputy Secretary, let me give a brief response and I'll ask the DOJ to supplement. There are 2 parts to the bill. The first part is about the amendments to the company's ordinance. We have to stipulate in the bill the application procedure, the documents to be submitted by the applicants, as well as all the factors that we have to take into consideration when approving an application. In many of the legislations under the law of Hong Kong, well, there are in total 39 enactments which have to be amended because they cover the definition of company. Originally, under our law, the definition of company includes only non-Hong Kong company. Locally incorporated company. We have to include domiciled company as well as non-Hong Kong company. So that's why we have to make amendments to not just the ordinance but also the other related enactments. Let's see if the DOJ has anything to add. Well, we've come up with such a thick set of marked up copy because we are adopting the usual practice under the company's ordinance. Well, we already have a fund redomiciliation regime, and that mechanism or regime has been effective. So we want to expand this mechanism to all companies. There are comprehensive provisions in relation to that regime about the application procedure and the documents that have to be submitted. We have to introduce a new part 17A, to the company's ordinance because of this. Also, we have to set out clearly how we should handle the situation if the company is a redomiciled company. We will regard the redomiciled company as a locally incorporated company with the deeming provision. However, still, in implementing the regime, we need the relevant provisions to support the regime. Apart from the company's ordinance, we have to make amendments to the 39 enactments, and we think it is appropriate for us to introduce the amendments to all these legislations. I have a simple question. I don't want to waste everybody's time. The administration said this is a usual practice. I understand that we have to proceed with the clause-by-clause scrutiny at this stage. It is no wonder it takes us so much time to scrutinize the bills in Hong Kong. Well, for this particular bill, there are 400 pages. In future, for similar legislative exercise, apart from going in such details, I think we have to adopt a more precise approach. You're making the entire business environment more complicated. I believe the administration all understands Ms. Kong's views. According to the administration, apart from the company's ordinance, the 39 enactments have to be amended because they include the definition of company, and the definition of company has to be amended. I wonder if you can introduce a provision with the wording referring to Cap 622 so that you don't have to amend all amendments. Is that what you're trying to say, Ms. Kong? I think the administration has to be prudent, but at the same time it has to be precise. I don't think the two approaches are mutually exclusive. Please take note of members' comment, administration. Members' comments noted. Any other comments from members? If not, let's proceed with the clause-by-clause scrutiny. Please note that the administration has already replied to the legal advisor's questions. The legal advisor's letter is in LC paper number CB1193/2025-01, and the administration's reply is in LC paper number CB-1216/2025-03. In the last meeting, we stopped at LC paper CB-1185/2025-01, page 8. That's clause 3 of the bill. Do members have any questions about page 8? If not, let's carry on from page 8 of the Chinese version of the marked up copy. The legal advisor will look at the English version at the same time. If members have any questions, you may press the request to speak button. Also, in order for the public to be able to follow our discussion, would you please read out the page number of the marked up copy as well as the blue bill when you raise any questions? Should we start from page 9 of the marked up copy? Before I begin, let me briefly talk about the bill. We will introduce a new section, Part 17A. This is because we want to implement our policy intent, that is, all provisions applicable to locally incorporated companies, they will apply to redomiciled companies. Also, provisions applying to non-Hong Kong companies, they will not apply to redomiciled companies. Also, for companies that are registered under the company's ordinance as non-Hong Kong registered company, there will be transitional provisions for these companies, which will become redomiciled companies. Let's look at clause 4. It is to amend section 53 in relation to the definition of relevant correspondence address. There will be an amendment because the company will submit the correspondence address to the company's registry. Clause 5 seeks to amend Section 71 of the Ordinance. That's page 11 of the marked-up copy. This is an amendment to the wording. Our law draftsmen have made the Chinese wording consistent through the amendment, and we have also made corresponding amendments to the company's ordinance. For the word registration, we refer to registration form, for example. Ms. Doreen Kong, I'm happy that the administration raised this point. I have no questions about making the Chinese wording consistent. Currently, the word register refers to two different meanings in Chinese. Can you tell us when the word registration will mean what? We usually refer to registering a form, or registering a document, and so on. The word register is usually used in the context of registered companies. After the amendment is introduced in future, when we talk about, say, a company needs to register a document or register a form, then we will use this word. Please carry on. Clause 6, page 12 of the marked-up copy. According to Section 78 of the Company's Ordinance, the Financial Secretary may publish a notice by Gazette to establish certain templates for the article, for the association's articles. The amendment or the articles will not affect the future domiciled companies. Page 13 of the marked-up copy, Section 83 of the Ordinance stipulates that the articles of a limited company must state that the liability of its members is limited. And this is to stipulate that the articles will apply to redomiciled companies in the future. Page 14 of the marked-up copy. Currently under the ordinance, if a company is a unlimited company, it will have to be stipulated. That's why we are introducing this amendment. Clause 9, page 15 of the marked-up copy. According to the ordinance, the articles of a company with a share capital may state the maximum number of shares that the company may issue, and this will apply to redomiciled companies. Page 16 of the marked-up copy. Again, here we are making the Chinese wording register consistent. Clause 11, page 17 of the marked-up copy. Under Section 89 of the Ordinance, there's a provision about formed and registered companies, and these provisions will apply to redomiciled companies. Clause 12, page 20 of the marked-up copy. According to Section 100, bracket 1A, the company must not register by a name that is the same as a name appearing in the index of company names. As a facilitation measures, we will allow redomiciled companies to adopt the same name as they carry on businesses in Hong Kong.
Clause 13, page 22 of the marked-up copy in Chinese. The registrar may change company name in case of failure to comply with direction. We will add a reference in this section to refer to the certificate of redomiciliation on top of certificate of incorporation. Clause 14, we can have companies that would be able to issue shares. We have amended the heading as well as the provisions to repeal fresh certificate of incorporation and substitute it with certificate because of re-registration. Clause 15, page 25 of the marked up copy in Chinese. Repeal of power to issue share warrants. This will apply in terms of the repeal of power to issue share warrants. We will have such power not only be made applied to local companies but also to domiciled companies. Clause 16, page 26 of the marked up copy in Chinese. It says that for charges, they should be from the commencement date of this section. And we have substituted it with material date, so that for a redomiciled company, it means the redomiciliation date. Yes, Ms. Kamen Khan. Thank you. I would like the administration to explain what the definition of the material date is, and why is it that in page 26 of the marked up copy in Chinese that you have to define redomiciliation date again? Thank you. On the definition of redomiciliation date, in section 820 there will be a reference, so that once the redomiciliation process is completed, the certificate of redomiciliation will be issued, and that will be the date that is the certificate is issued. That would be redomiciliation date. Okay, so I think that means the date would be the company has been issued with a certificate of redomiciliation. But let me say this, in section 334, what is the difference between material date and specified date exactly? Why are there different expressions? Well, for specified dates, they will apply to companies that are not redomiciled companies also. So for a company that is not a redomiciled company A, the specified date would mean the 3rd of March 2014 when the company's ordinance came into effect, and B would apply to redomiciled companies. I understand what is being said here, but then essentially specified dates would mean the same as material dates, so why do you need two different phrases for this same expression? Deputy Secretary. Let's ask the DOJ colleague to explain why there are different expressions used. Thank you. For section 139, specified dates, as Ms. Kamen Khan noted, the contents of the specified date are the same as the contents for material date for the amendment of section 334. But then, because we are talking about different sections, one is section 139, the other is section 334, we have used a different label for the definitions. Why not have the same definition then? I think it's a very simple question. Why not just have specified dates for both of them because the contents are the same? Right, why not use the same term? Deputy Secretary, we will follow up on this after the meeting. Perhaps you can give a written response on how you will follow up on this issue. Chair, I have another question on the contents. For section 334, whether we're using the expression material date or specified date, but then we're referring to redomiciliation date, and that is the date on which a certificate of redomiciliation is issued. So say for section 334, it is on specified charges, right? So there are companies that are already registered in Hong Kong under Part 16. Before under Part 16, they are not required to register certain charges, but with the companies redomiciled on redomiciliation date, they will need to register certain charges. And we talked about this, and the company's registry colleague gave a response last time. But then we have some charges that were originally there not cancelled. Well, not cancelled with the jurisdiction of incorporation or their last domicile. So there is some uncertainty. So should they keep their charges registered in other jurisdictions? Should they cancel the charges in the other jurisdictions? Or will we have legislation here or in other jurisdictions that will deal with the situation? Can the administration explain how this works? Deputy Secretary. I will give a simple answer and then I'll let the company's registry colleague supplement my answers. For redomiciliation date, as we said earlier, that is the date on which a certificate of domiciliation is issued. The policy intent is that on the particular date, that would already mean the company is regarded as a Hong Kong incorporated company and their liabilities will be on the same level as Hong Kong incorporated companies. And that would apply to companies registered under Part 16. And as I said earlier, they will have 1 month to register the necessary charges. I'll let the company's registry colleague supplement my answers now. Thank you, Chair. Thank you, Member, for asking the questions. Under Companies Ordinance, for companies registered under Part 16, the non-Hong Kong incorporated companies are required to register certain charges. These will not change, but then for charges that are not required to be registered right now under Part 16 but are required to be registered under the redomiciliation regime, we will deal with that in Section 338A. For some charges that were already there before redomiciliation and the charges exist still after the redomiciliation, they need to register such charges within 1 month upon redomiciliation. So we will refer to, in particular, the redomiciliation date, whether the charge subsists on the redomiciliation date. Once the companies become redomiciled companies, like other Hong Kong incorporated companies, they will need to register the charges within 1 month upon redomiciliation. I understand the operations of the provision, but I'm thinking in law, will that affect the priorities of the charges? So are you referring to the registration date of the charges to be effective, or are you referring to the original dates on which the charges were created when determining the order of the charges? So which dates will you be referring to? Will you be referring to the redomiciliation date or otherwise? How will it affect the creditors? I think you need to give some possible scenarios for illustration for different kinds of assets, for example. For certain assets that are not required to be registered right now, and with them having been redomiciled, they will need to register. What will happen? How will it affect the creditors? Let's see if the company's registry will respond to this right now. Thank you. Our line of thinking is for charges that have already been created before they have been domiciled to Hong Kong, they should register such charges in accordance with the laws of their last domicile. And we should follow the priorities of the charges in the jurisdiction. But then for charges that have already existed and been created, we do not want to affect the continuity of the charges, and the charges already had an order in another jurisdiction. Under our law, we will ask them to register the charges that have already been created so that they can tell people inspecting the company's register, people can see that they have charges that subsist. I understand your requirements, but I'm talking about the consequences. They need to provide some analyses. Say for shares. In Cayman Islands law, they would need to register as charges, but say in Hong Kong it's not necessary, or there are some that are not registered in other jurisdictions, but in Hong Kong that are required to be registered. Will that affect the order of the charges? I know there are many different types of assets. You really need to tell me, though, how it works, say for IP, say for vessels. So for non-Hong Kong incorporated companies, they do not have to register certain assets as charges, and they have already registered these as charges elsewhere. How will it work, and how will the order of the charges be? You need to really show us. I think the administration understands your points, and they can provide a written response after the meeting. We will provide a written response after the meeting. Thank you. Eric, please proceed. Thank you. Clause 17. For companies incorporated outside Hong Kong, they have some charges that are outstanding. They need to make sure they are upholding such liabilities, and we have added section 336A in order to ensure continuity in that regard. Clause 18, it amends section 337. It talks about consequences of contravening sections 335 or 336. And these are changes that would reflect the change in section 336A. Clause 19, we have added section 338A as the company's registry colleague explained earlier. Redomiciled companies must register charges created by company before redomiciliation date and charge existing on property acquired before redomiciliation date. We are also adding section 338B that would explain the meaning of specified instruments. And this is a meaning that is already in the company's ordinance. Clause 20. It adds section 339A. The original section 339 would require some charges to be registered, and we are adding supplementary provisions in section 339A to make sure the companies register the relevant charges to ensure continuity of the records. Clause 21. We will add section 348. It is also a supplementary provision where companies incorporated outside Hong Kong would need to continue to make sure that they fulfill certain liabilities. This is again to ensure continuity. Clause 22, it amends section 341 on issue of debentures. The companies must register the particulars of the issue of debentures, and the amendments would cover section 338A charges and the relevant deadline for registering such. Clause 23, it amends Section 342 for companies to register particulars of commission, etc., in relation to debentures. Our amendments will again give effect to Section 338A on the registration of charges as well as the deadline. Clause 24, it amends Section 346, extension of time for registration. We are again trying to have more references to accommodate Section 338A.
Clause 25, page 49 of the marked up copy. This reflects our policy intent. Section 357 defines non-Hong Kong body corporate, and we clarify that this definition will not include a redomiciled company. Clause 26, while the coming clauses are quite similar, the overarching principle is that Section 359 of the ordinance states that certain companies could be exempted, including small-scale companies as well as some private companies. And we are introducing consequential amendments to cover redomiciled companies. Clause 27, page 52 of the bill, seeks to amend the provisions concerning private companies. Page 55, we amend Section 364 to cover the companies that meet the requirements, that are the shared capital companies. And 365, they cover eligible private companies or holding companies. Page 59 of the marked up copy is about accounting reference period. Section 368 stipulates the accounting reference period. We have introduced a definition. For a domiciled company, the first accounting reference period begins on its domiciliation date. Clause 31, page 63 of the marked up copy, we are amending Section 369 of the ordinance in relation to the relevant anniversary. These provisions will apply to redomiciled companies. Clause 32, page 64 of the marked up copy, we're amending Section 395 so that the appointment of the first auditor by directors will apply to redomiciled company. The following page, there is a phrase concerning not a company incorporated in Hong Kong. For the subsidiaries, they concern redomiciled companies, so we are amending this part. Section 431, period for laying and sending financial statements. We'll amend the provisions so that companies incorporated will cover redomiciled companies. Section 453, we are adding subsection 3A. For a redomiciled company, if the company has stated in the form the first directors of the company, then starting from the redomiciliation date, that person will become the first director of the company. Page 71 of the marked up copy, there is a consequential amendment. It is an amendment concerning private companies. Clause 73, page 72 of the marked up copy is about company required to have company secretary. Again, for a redomiciled company, the first company secretary of the company will become the first company secretary of the company after it is redomiciled to Hong Kong. Page 74 of the marked up copy. There is a section under the ordinance no loans can be made to director or body corporate if there is no prior approval. So there's an amendment to this. For companies incorporated outside Hong Kong, they will not be considered as redomiciled companies in Hong Kong under this part. For companies incorporated in Hong Kong, we will add a reference here to cover redomiciled companies. Page 75. The original part is about making loans to directors, so we will have a consequential amendment. Page 75. Again, it is about the requirement of making loans to directors. For companies incorporated outside Hong Kong, they will not cover redomiciled companies. But for those incorporated in Hong Kong, they will cover redomiciled companies. And Section 504, we are introducing a similar amendment. It's just that this part is about making transactions. According to Section 504, without the director's approval, the companies cannot make the relevant arrangements, and we are making an amendment stating that for companies incorporated outside Hong Kong, they will not cover redomiciled companies, but for those incorporated in Hong Kong, they will cover redomiciled companies. Page 81 of the marked up copy, it reflects a similar amendment. It's just that this part is about company not allowed to make a payment for loss of office to director or former director. Next page. Person must not make payment for loss of office to director or former director in connection with transfer of company's undertaking or property. For the exceptions set out here, there is reference to wholly owned subsidiary of the company, and it will not cover redomiciled companies. Next page. Person must not make payment for loss of office to director or former director in connection with transfer of shares resulting from takeover offer. There is mention about body corporates set up outside Hong Kong. So we are making an amendment stating that this will not include a domiciled company. Next page is about the accounting period. We have made an amendment here. Like previously stated, for domiciled companies, the accounting period will be set according to the incorporation date of the company. And next page, we're making the wording consistent. Page 89 of the marked up copy. According to the Companies Ordinance Section 645, companies have to appoint directors in accordance with Section 453, subsection 3 and subsection 4. we are going to add reference to section 454 bracket 2 and bracket 2a to this part. Page 91 of the marked up copy. Like the above, this part is about appointing company secretary, and we're going to add the references to certain sections to this provision. Page 92, about registered office of company. For a redomiciled company, the intended address of the registered office will be stated on the application form. The address will be effective starting from the date of the redomiciliation. Next page is about the annual return. Yes, Mr. Lee, I have a question concerning the display of the address. For companies currently registered under Part 16, say if the company is incorporated in BVI with limited liability, if these companies are redomiciled to Hong Kong, will they have to, or how should they display their address? They will not have to display their address concerning their incorporation. Perhaps I'll ask the company's registry to clarify. There is no specific requirement asking where the company is incorporated. After the company is redomiciled to Hong Kong, they will be regarded as any other companies locally incorporated. Page 90. Hold on, Mr. Lee, Miss Doreen Kong. I have a question. I'd like to go back to page 88 of the marked up copy, subsection 5. Just now you mentioned about when we should use the word register. Maybe you've already talked about this. This part is about the articles. How come you mentioned the word register here? I thank Ms. Doreen Kong for the question. Thanks for pointing out the inconsistency. Let me explain. We explained when we would use the word register. We are adding the word register here. This is because this belongs to the original provisions of the company's ordinance. And to make it consistent, our law draftsman would like to cover the different meaning of register under this part. Perhaps I'll ask the DOJ to see if they have anything to add. Thank you, Chairman. Under the existing section cap 32 of the Hong Kong laws, it is the former version of the company's ordinance. Under section 622, register, 登記 is used, but in the original ordinance, 註冊, which also means register in English, is used. We want to keep the wording consistent. For the old wording, well, we don't think it is necessary for us to amend the wording. So we want to cover the different meaning of the term register in the amendment. For parts where 登記 and 註冊 were used in the original provision, we want to keep them.
All right, clause 51. It amends section 662 to add subsection 2 for redomiciled companies. adding section 2A, they must within 42 days after the company's return date submit to the registrar an annual return. We'll also add subsection 2B. The company's return date in respect of a particular year is the anniversary of the company's redomiciliation date in that particular year. Clause 52. We are amending section 744. The original section 744 would have registrar being notified on founder members, but for redomiciled companies, while they do have founder members, but there may be changes of members upon redomiciliation. So for a redomiciled company, the letter should be sent to each member of the company whose name and address are known to the registrar. In clause 53, we have a similar change. Excuse me, Ms. Doreen Kong. Chair, I don't really understand the amendments made to section 744. Why is there such a difference for a company other than a redomiciled company and for a redomiciled company? Why is it that for redomiciled companies you have no founder members? I don't really understand. All right. Thank you, Mr. Kong. In 2C, if there is no officer, and if we're talking about non-redomiciled companies in the company's ordinance, the existing section, the registrar should send the letter to each founder member. In the case of redomiciled companies, we will not say founder members because for redomiciled companies, the founder members may not be the same. There may be a change. So when the companies submit redomiciliation forms, they would have registered the relevant members. So for redomiciled companies, we think it is more appropriate to make sure the registrar can submit or send letters to each member of the company whose name and address are known to the registrar. But then what happens if there are many members, say for a listed company? What is going to happen? Do you have to send it to each of the shareholder? What happens to listed companies? Because here, for a redomiciled company, it should be each member of the company whose name and address are known to the registrar. If there are hundreds of them, will the company's registry send letters to all of them? I think I understand the intent of the administration for not saying founder members. But the point is, if there are so many members, what is going to happen in operation? Thank you for your questions. Let me say this. The provision would apply to the registrar for deleting names of companies that are no longer in operation or will not continue operation. So, when companies are not in operation, they will need to notify the registrar of such. So what happens is, for listed companies, there will not be such case because they would not be required to do so. But then public companies can have more than 15 members. Even if we're not talking about listed companies, can the company's registry colleague talk about the legislative intent for making such a distinction between redomiciled companies and for companies that are not redomiciled companies? Thank you. Under section 744, if the registrar thinks the company is not in operation or the registrar would like to know whether the company is in operation, the registrar may send inquiry letters to relevant members to check that. And in Section 744(2), it says that not only does the letter have to be sent to the registered office of the company, but also when the registrar has not received notice from the company's registered office, the letter must be sent to senior personnel of the company. If no senior personnel is known, then the letter will be sent to members. So what happens is when a company is believed to not be in operation and the registrar would like to delete its name from the register, the registrar would have to inquire whether the company is in operation before they actually do so. So in subsection 2, the registrar is sending inquiry letters to the registered office of the company, senior personnel of the company if there is no response from the registered office, or founder members if senior personnel of the company is not known to the registrar. Now, for redomiciled companies, we are adopting the same process to find the registered office first, and then if there's no response, we will send it to the company's senior personnel. If not, we'll send it to the members of the company, again to inquire whether the company is in operation. Mr. In Kong, I think we need to be careful because in section 744(2), the letter must be written and must be sent. So the administration's colleague is talking about they're guessing what the intent is. I think they shouldn't guess. They should inquire what the intent is or was when the company's ordinance was written. If you don't even know the company's senior personnel, how will you be able to identify the members? Chair, I believe the legislative intent of this section is to make things doable. If the company is believed to not be in operation and you cannot find the person in charge, you're just trying to find the members and you think the company is not in operation by confirming with them. That would be it. That is easy. But then you shouldn't assume companies that are believed to not be in operation to not have many members. But I will check the legislative intent myself of this section in particular. Administration, we will also look up the relevant information and give a response later. Thank you. Please proceed. Clause 53. It is a similar situation. The original section 745, the registrar must follow up under certain circumstances if a letter having been sent a month ago has not received any response. The registrar must send a registered letter. And again, here, the last resort is to send the letter to founder members. And we have a similar approach for domiciled companies for each members. Clause 54, it amends section 747, the registrar's duty to act in case of company being wound up. We have made a similar change. Clause 55, section 772, it amends this section to say for registrar may change company name in case of failure to comply with direction. Right now we have only the certificate of incorporation. We will add or the certificate of redomiciliation to cover redomiciled companies. Clause 56, it amends section 774. In subsection 1, we will add a definition for place of incorporation. In clause 57, it amends section 776 for certain non-Hong Kong companies applying for registration as redomiciled companies, but the registration is revoked. Upon revoking of registration, the company must apply to be a registered non-Hong Kong company again, and there are some consequential amendments with the references. Clause 58, it adds section 778A. The company incorporated outside Hong Kong must inform the registrar of their name change, and for companies did not change such name, they need to make sure the records are intact. Clause 59, it amends section 779. In subsection 1b, when the registrar receives the applications to change the name of the company, the registrar must issue the relevant return or response to the registered non-Hong Kong company, and we have substituted the current expression with the situation to accommodate the situation for if the return is delivered to the registrar under that section, not because of section 778A. Clause 60, we are adding section 787A. Again, it's supplementary provisions, where a company incorporated outside Hong Kong ceases to be registered non-Hong Kong company because of registration under section 820C. This would essentially give effect to companies having to make sure their liabilities are continued. They should continue to uphold such liabilities. Clause 61, it adds section 788A supplementary provisions that would have a similar effect to the last provision. Clause 62, it amends section 789. In the Chinese text, we have a technical amendment to more accurately reflect the English text. Clause 63, it adds section 789A. Excuse me, Eric, please wait. Mr. Yin Kong. Well, I think with the amendments to the company's ordinance, many provisions are supplementary provisions. So if you are not, the company has not been doing something before redomiciliation, they need to do it. So I'm asking the DOJ, why do you need so many supplementary provisions? Why not just have a particular part that would contain supplementary provisions that would apply to all of these existing provisions? This is very clumsy. Why can't you have once and for all under this part a simple supplementary provision? Because I've seen so many supplementary provisions and they are similar. Why doesn't the DOJ make use of a particular provision for all the supplementary provisions? Because for me, it is quite troublesome to refer to all of these different supplementary provisions. DOJ, I understand Mr. Yin Kong's concerns, but then with the supplementary provisions, it is important to make sure for, say, company registration, if they do not do something within a particular period of time, there will be consequences. We have reviewed the relevant provisions. We believe it is important to make sure for each of the provision we have supplementary provisions to provide for the consequences for redomiciled companies. if we are a bit more lax in our drafting, we will have some uncertainty with the provisions. For statute law, it is important to have certainty. We do think it's somewhat clumsy, but we have reviewed this drafting and think it's necessary. I don't think it is complex. I think it's just clumsy and unnecessary. I think I understand the administration's point of making sure it is simple, but then we should also strike a balance to make sure it is also easy to understand. Thank you, Ms. Doreen Kong. Mr. Poze.
Chairman, I'd like to weigh in on the debate we've had just now. Is it too late now? To quote what Ms. Doreen Kong was saying, you could have one section to cover all amendments, and you may cover all the consequences. I think it is enough to have just one section dedicated to it. Otherwise, the compliance cost may be too high for prospective companies. This defeats the purpose of trying to attract companies to come to Hong Kong. I'm not sure if it is too late now, but I just want to raise this possibility that we could simplify the amendments by consolidating them into one section. Deputy Secretary, any response? Like the DOJ said, we want to make it clear in each provision. The other approach may be to have just one section covering all these amendments. For companies, they may have to search for the provisions that applied to redomiciled companies. Since we have already come to this stage of the drafting, I think it may be more appropriate for us to adopt this version. Understand that we are at this mature stage of drafting already, but in future, could you consider making things simpler for members of the business sector to have an easier understanding of our legislations? Yes, Ms. Carmen Khan. Is it easier to have a supplementary provision in each section? I'm looking at section 105. A lot of the sections point to sections 802 about the redomiciliation process, for example, about whether the 120-day period could be extended. Section 776 states that a non-Hong Kong company that establishes a place of business in Hong Kong has to be registered in Hong Kong within a month. And for this section, with the new redomiciliation regime, supplementary or consequential amendments are added to this part. If you look at section 776, subsection 1C, it is a newly added provision. This is because subsection 1B, Roman numbers 1 and 2, is about what a non-Hong Kong company has to do. And for subsection 1C, it is about a non-Hong Kong company whose registration may be revoked. And also, the subsequent provision talks about what the redomiciled company would face if the deregistration is not complied with. It is said here that a non-Hong Kong company falling within the description in subsection 1C must, within 1 month after the revocation order made under section 820F takes effect. Is it the case that you issue a certificate of redomiciliation to a company, and the company will be redomiciled to Hong Kong on a certain date if that company fails to deregister from the original domicile? What will happen? So if the company fails to deregister from the original domicile, you will regard that company as a non-Hong Kong company? For Section 776, it applies to a non-Hong Kong company that establishes a place of business in Hong Kong. A non-Hong Kong company may apply to redomicile to Hong Kong. After the application is done, we will issue the company a certificate. And within 120 days, that company will have to deregister from the original domicile. That company will have to complete the deregistration process in the original domicile. If this company fails to deregister from the original domicile within 120 days, that means the redomiciliation procedure cannot be completed. Under such circumstance, the registrar will, under Section 820F, revoke the certificate. That means this company will no longer be regarded as a redomiciled company. So under 776, when a non-Hong Kong company has its registration revoked, it will have to apply to the company's registry to become again a registered non-Hong Kong company. Any follow-up questions? Ms. Carmen Khan? Is it how things should work? That means you are changing the identity of the company repeatedly. This non-Hong Kong company which fails to deregister from its original domicile will have to apply to be a non-Hong Kong registered company again. This company applies to transfer its domicile to Hong Kong, but it fails to deregister from the original domicile. That means once the certificate of redomiciliation is issued, it will no longer be a registered company under Part 16. But when it fails to deregister from its original domicile, it will have to apply to become a registered company under Part 16 again. So there's a chance that a company may have to change its identity a few times. Yes, this might be a scenario that we may face. Ms. Doreen Kong. I think there are over 20 supplementary provisions in this bill. This is a very thick bill. I strongly suggest an easier way to deal with it. Well, supplementary provisions start to emerge starting from page 20 or 30 of this bill. Can the administration consider adding one part at the end of the bill? The idea is simple. You want the redomiciled companies to fulfill their obligations, and if they do not comply, they will face penalty. This is the message you want to send out. Why not add a provision towards the later parts of the bill? In other jurisdictions, in their laws, the wording used is that with adaptations, modifications, the companies will have to comply with the laws. Well, this is a crucial piece of legislation for us to attract companies to come to Hong Kong. Like Mr. Porche said, while we have already come to this stage of the legislative exercise, I strongly suggest that we find an easier way to introduce amendments. I hope the administration would consider the members' views in future. For similar legislative amendments, perhaps there could be a simple provision that covers all the supplementary provisions instead of having one supplementary provision in each section. Clause 63, page 117. This is again a transitional provision. It is about a registered non-Hong Kong company submitting their accounts. We suggest having registered non-Hong Kong company to replace the wording company. This is a transitional provision. Page 120. Section 791 states that if certain particulars are changed, the registered company will have to submit the details. According to the amendment, the redomiciled companies will have to follow the same practice. Yes, legal advisor. Subsection 8 is added under Section 791 in the bill. If the registered non-Hong Kong company contravenes the relevant subsections, it would be an offense. We've consulted the administration and asked whether the prosecution will have to prove the mens reas. And according to the administration, an honest or genuine mistake could be a defense. I have a follow-up question about this. According to subsection 8, apart from companies, every responsible person of the company or every agent of the company who authorizes or permits the contravention commit an offense. In relation to the liability, it is stated in Section 622, Section 3. And this would apply to every responsible person as well as every agent of the company. And we believe that under such circumstances, a mens rea will have to be proved. Could the administration please clarify if the responsible person of the company or an agent of the company who commits this offense with the mens rea will have to be proved? DOJ. We consulted the prosecution department about this. We asked them about the burden of proof. It reflects the policy intent. And so we checked the relevant provisions. We think this is in line with our policy intent, and the prosecution department has already looked at this provision, and they decided whether the common law defense would be applicable. And like our reply to the legal advisor, it's listed out in the annex. If it is found that the responsible person of the company commits an offense, and if it is decided that mens rea will have to be proved, well, we'll have to talk to the prosecution department again to see how we will deal with such a situation.
好，可以繼續 Eric。
Please proceed, Eric. Yes, Mr. Pose. Please do not think we are being argumentative here. But for criminal offenses, the burden of proof, the standard of proof, the administration did say in statute law they are trying to provide certainty. So they are repeating supplementary provisions over and over. But as Mr. Ring Kong said, for transitional periods or the responsibilities of redomiciled companies, the administration thought it necessary to provide supplementary provisions over and over, but when it comes to criminal liability, they think it's unnecessary and they think it is already in common law. It seems that they're approaching this very differently. I'm not exactly criticizing this approach, but I would say this: it is inappropriate. I think the administration should review this. I think it's not too late to change things at this stage. A global amendment would work to delete all the unnecessary provisions. The chairman said it may be too late and we can do this next time, but will we actually do this next time? I think we can lower compliance costs by making the bill shorter. I think many technical amendments aren't exactly necessary. I think the administration can do something about this. Administration, any response? Deputy Secretary. As the DOJ colleague, we will provide additional information if necessary, but I think the drafting approach that we have is appropriate, and we want to make sure we are expediting the bill's provisions of the real scrutiny. Thank you. Well, we have already been going for about an hour and a half. Can we take a break and we can come back at 10:38, 5 minutes later? Thank you.